Section 2.4 is about building a just society under the Charter. The section begins with a quote from the Right Honorable Beverly McLaughlin, who served as a Chief Justice on the Supreme Court for 17 years. This quote is really good. You should read it. In the introduction, we're reminded that the Charter makes sure that the government and its agents adhere to certain standards and uphold certain principles in their conduct, behavior, and in any legislation that is passed. It identifies the rights that all Canadians have and that the government can't infringe upon. Although the Charter puts restrictions on the government and its agents, ensuring that Canadian citizens' rights to autonomy and freedom are maintained, sometimes some rights may be subject to restrictions. So applying the Charter, where there are competing rights, requires careful balance and careful analysis. One of the first concepts discussed is that of jurisdiction. Jurisdiction proscribes the fence posts around which certain legislation, or in this case, the Charter, applies. There are a couple of case studies that are presented that fall under Section 32 of the Charter. It defines its own jurisdiction and tells us specifically in which case or which situation the Charter actually has power. The first case study is McKinley versus the University of Guelph. The case explores the mandatory retirement policy of one of its employees. Please familiarize yourself with that case. The next subsection explores how you can actually challenge the government in court. There are two cases. The first one is a situation in which the Charter is brought to bear because there's an alleged Charter violation. Section 24, subsection 2 of the Charter examines the exclusion of evidence in a criminal trial. In this case, the question is whether or not an individual's Charter rights were violated in sourcing evidence that otherwise would not have been found or brought to the attention of the court. You see, judges are required to exclude evidence that was obtained in violation of Charter principles. This can be a tricky item for us as citizens to get our head around, because on one side, the evidence may indicate quite clearly that somebody had engaged in illegal or unjust behaviors. Thus, justice being done would have the individual charged and convicted. Then again, the agents of the state are not allowed to violate Canadian citizens' Charter rights, and that none of the evidence gathered in any way infringes upon a person's rights should be permissible for use in the court. The police would need to go about finding that evidence and gathering it in a legal way in order to have a sound case put forward. In this case, the government would need to put forward what is called the grant test. Please take note of its key pieces. Firstly, the seriousness of the Charter infringing conduct that is being explored. Secondly, how the breaching of the Charter impacts on the accused, Charter, or protected interests. And thirdly, is society's interest in adjudicating this case on its merits. Two case studies are presented. The cases are R v. Connor and R v. P.J. It actually is JP, but they reverse the initials of the individual for the case. Please read these cases and take a look at how you would apply the grant test. At the end of the first case, in R v. Connor, you are asked a couple of questions. Should the breathalyzer test be allowed to be used, or should it be excluded? Jot down some of your thoughts and take a look at how the grant test applies to this case. At the end of the second RVPJ, case, it asks the question, should the knife be allowed to be entered into evidence, or should it be excluded? Again, jot down some of your reasons for your decision. Then take a look at the actual decisions, which are shown on the screen, and how they were ruled upon. Did your thinking match up to the actual decisions? If not, reflect on the merits of the decisions as they're presented. There's a quick quiz that follows, that follows this section. Please check your understanding. It's not marked, but it is a self-assessment that provides you with good feedback on your current understanding. When can charter rights be taken away from individuals? There are a number of sections or limits that are applied to our individual charter freedoms. So let's take a quick look at them. Section 1 of the Charter. There must be a proven charter violation before a case or lawsuit is even pursued against the government or its agents. If the judge decides that the government or its agents have not violated any of your charter rights, then that challenge is dismissed. On the other hand, if the judge determines that the charter rights were infringed upon, then the case moves to Step 2. And Step 2 is referred to as the Oakes test. This is discussed more fulsomely in the passage, but I'll give you a quick summary. The Oakes test will be used to determine whether or not a violation is justified. That is, a violation of somebody's charter rights is justified in this case. So the Oakes test has a number of features, and it requires the government to prove all of the following components. First of all, is the legislative goal pressing and substantial? For example, is the objective sufficiently important to justify limiting a charter right? A charter right is an important thing. It needs to be significantly important. Secondly, is there proportionality between the objective and the means used to achieve it? Well, there's a couple of pieces here. First of all, a rational connection. The limit must be rationally connected to the objective. There must be a causal link between the impugned measure and the pressing and substantial objective. Next, minimal impairment. The limit must impair the right or freedom of that individual no more than is reasonably necessary to accomplish the objective. The government will be required to show that there are no less rights-impairing means of achieving the objective, and that is in a real and substantial manner. In other words, if the government is making a case that it needs to remove a charter right from somebody, it needs to be the least possible amount of removal. This is termed minimal impairment. That is, the individual's rights are impaired to a minimal extent. And the final piece is final balancing. There must be proportionality between the deleterious effects of not allowing the government to proceed, or for allowing the case to proceed. So this final balance must be proportional between the deleterious and the salutary effects of this law. If the government can prove all of those components, then the case moves to Step 3. If the government can't prove the Oakes test, then the government will have to provide a remedy. That is, the government automatically loses this challenge and needs to satisfy the judgment made by the court on behalf of the individual whose rights were infringed upon. So this subsection concludes with a discussion on how the reasonable limits clause has been used, and would be good to take down some notes on this section. The next video will look at the restrictions on the reasonable limits clause and the consolidation portion of this unit.